Tamara Ćapeta, Advocate General of the Court of Justice, welcome to the Hertie School, to the Jacques Delors Centre. We're really pleased that you could take the time to spend a few minutes with us talking about your career. And I'm also very pleased to welcome Ana Bobić, who's a Senior Researcher at the Jacques Delors Centre as well, and who worked in the cabinet of Tamara Ćapeta for several years. So we're getting a bit of a reunion between the two of you here today. Maybe I can start, Tamara, by, I think the EU law community, they will know well your opinions. They might know a little bit less about you as a person, your background, what led you to become an Advocate General in the first place.
Thank you for inviting me. First of all, I'm really happy to be here. A little bit about my background. Well, I'm Croatian, first of all. So I studied law in Zagreb. I finished my law degree there. And then after that, I went to Bruges. And Bruges has a College of Europe, which is devoted to EU law. And that is where I fell in love with EU law and decided that this is what I'm going to do in my life. And then not immediately after I returned, I in the end ended up in academia, where together with Siniša Rodin, who is also now judge at the Court of Justice, we initiated the Department for EU Law. And that was fun times because we were doing something new. And that was good 10 years before Croatia became member of the European Union. So we had the generations of students that were prepared for membership, so to say.
What I find really interesting about your academic background is that you studied the job that you now hold, right? So we actually discussed when we met earlier that even the term Advocate General, you came up with a Croatian translation of it. So I guess you must have also had a notion before you became Advocate General of what that job would be like, of what you wanted to do with that job. Maybe you had certain role models that you'd seen at the court or you'd studied.
It is true, it is true. Advocate General is a strange position of which nobody knows what this is about. In Croatia, when I was doing my PhD, which was in Croatian, I had to invent vocabulary for EU law, as we didn't have it at the time. And so I needed the term for Advocate General, and knowing that Advocate General is actually not an advocate, that it is an independent person, I translated it into Croatian as something that in translation into English now would be independent advocate. So true, I have named in Croatian my current position at the Court of Justice. So this is nice, this is fun. Most of my research was devoted to the Court of Justice. So I researched what the court does and the procedures in the court and how the court interprets law and so on. You asked me about whether I had role models at the Court of Justice, you mean. I could say that I did have one Advocate General, and that was Francis Jacobs. Mm-hmm. He was my role model, and I'm still actually working on the cases in which I read his opinion again, some of his opinions again, and maybe sometimes they still influence my thinking.
What do you think made him such a good Advocate General? Because of course that sort of implies something about what you think the job should be about. What are the ingredients that make you successful in this job?
I would say that good Advocate General is someone who can struggle with the difficult things in the cases in a relatively simple way and make judges think. That's the first thing. But make judges think in the way that everybody else understands what they're saying. And that's the most simple way how to say it. And that would be the ideal to attain, which of course is impossible, and mostly it is impossible because of time. You need more time than we have. So the most scarce resource at the court is, I would say, time.
Maybe we can go a bit into the court as an institution, right? Because I think people might have an understanding of formally what the court does, but they might not have a good understanding of what it's like to work there, what it's like as a workplace. Maybe I can bring you in, Ana, because obviously you've also been working at the courts in a different function from Tamara. What's it like to work in this institution?
So to come every day at work, and there are these long, beautiful corridors full of court reports, and you really feel like you're part of an enormous machine that's doing something very important. Another thing that is really striking about the court is how multilingual it is that you enter the building, and from that moment you will have heard dozens of different languages. You see this European multilingualism in action in a really incredible way. So it's really, a luxury to work there. A strange thing I think about the court, it's very secretive. I don't think that's strange about it, but it's strange being part of it, I think. Is that I felt, when you're in academia, you write about what interests you, you can talk to your colleagues, and at conferences everywhere you can say your opinion, but when you're at the court, you kind of feel this weight of something very doing important work, but you can't really say everything about cases.
And it's interesting about the Court of Justice because it's not in Brussels, it's sort of detached, right? And there is this perhaps perception that Luxembourg, there's a risk that it sort of becomes a bit disembedded from European society, from the national courts that it works with, these political institutions. But the current president has been trying to address that, make the court more public, make it more open. So how do you think you deal with that, this sort of distance potentially between the courts and the European public, between European institutions and so on?
I don't think that today it is so distant as it was once, when Eric Stein was writing about the court being tucked away in the fairy duchy of Luxembourg. The court is currently doing quite a lot of making itself known. Yeah. First of all, and I think this was a very good move, we started to transmit the hearings, because the idea is that everybody has a right to attend the hearing. So now we have started transmitting all grain chamber hearings, and we are moving into transmitting also 5 judges chamber hearings. It is happening now. I think my next 5 judges chamber hearing is going to be transmitted as well. So this is one thing. The other thing is that now, I don't know whether you have noticed this, but there are these short movies when judges, when they have some important judgment, tell us something about the judgment, what the judgment is about, and what are the core findings of the court. Maybe something done for the newer generations, for whom they say they don't have really concentration to listen to the longer things, so they did it like that. And we also have, as Anna said, we did secretive and so on, but once a year, not very often, we have open days. And that is also very nice. There is a lot of people visiting the court, and then they are shown all these secret parts.
Maybe we can move on a bit to your opinions, to the substance of European law. And I think it's safe to say that so many of the most interesting cases that have reached the court in the last few years, they've ended up in your portfolio, let's say. There are cases where you've written very interesting opinions. So the Danish ghetto case, cases involving Frontex, cases involving EU values. What kind of brings these cases together? So is there a Tamara Ćapeta approach to EU law? And I thought, one potential common thread really is the idea of kind of liberal democracy and the constitutional state. So in your opinion, in Commission versus Hungary, this big Article 2 case, you write there that the treaty framers established a certain vision of a good society, and that society was namely a constitutional democracy that respects human rights. So that's one potential candidate for bringing these case law together, the idea of constitutional democracy. What do you understand by that term?
What I did call constitutional democracy that respects human rights in my Commission with Hungary opinion is actually how I do see European Union, and I personally believe that it was, and it still is, the intention of the member states, but also not only member states, but also of its citizens, to create some kind of polity, okay, that is going to be a joint polity, common polity, that is based on these values. So if in a way, my belief is that these values are shared by both European Union as a new separate entity, but also all member state societies, or if you want to talk constitutionally, also their constitutional orders. And what we are facing today is a problem with maybe some of these composite parts of this composite society have changed in a way that doesn't fit anymore this shared model anymore. Then this certainly wouldn't be anymore the same European Union that we have at the moment. So the European Union that is defined somehow through not necessarily only Article 2, but all these values that we were actually developing through all this case law, and not only case law being accepted in the societies, in the member state, not only by courts, but also by politics, no? In large, in most situations, not always. I personally believe that even Eastern European countries, some of which were those who created that problem that I just talked about recently, actually became members of the European Union expecting precisely to become part of the liberal democracy. So this is more or less, if you want, my vision. Now, of course, I work with cases. So at the court, we don't make big theories. We are not working from big theory down. You get case, and then this case asks you to think about something. You get a fraction of what you have to think about, and then more cases together, then maybe in the end create some bigger picture, or some bigger picture starts creating itself. You need to come with some idea, but you have to stay open for these ideas to be changed. So,
I mean, maybe then we should move to you, Ana, as the person with the big ideas, the big theories. What do you make of this idea of European society, right? So, you see it mentioned in some of Tamara's opinions. It's become a big scholarly concept. It finds its way into other case law. Is this a useful idea? What are some pitfalls associated with it?
I mean, I think the way that this term was sort of developed in the literature is kind of like this cohesive notion behind which we can all rally together, right? I think what makes me slightly uncomfortable about the way that even the court perhaps uses it, perhaps that is used in your opinion as well, is this really disconnect from society in real life. This idea that courts or lawyers, legal scholars, can through legal norms tell us who we are. The idea of a society is something like a promise. It's something that we can normatively strive for, but we can't do it through legal texts or through legal school. I think we can't do it through legal scholarship. It's so in some ways, if legal scholars or legal actors such as the court do want to say something about the society, then there needs to be something more than law in it. There needs some sociology, social theory, or the citizens of the EU need to somehow find themselves reflected in the stages where it is talked about society in a legally authoritative way. I think for now I find a great disconnect between law and real life.
But isn't it inevitable that we have to engage with that concept? I mean, it's kind of, lawyers are forced to come up with imaginaries of what a good society is. And, without it, we're a bit lost. So you could see the job of the lawyer is bringing together these things, sort of a legal concepts grounded in rules in the treaty and an understanding of society that's based on empirical observation, sociological theory. So it somehow finds its way into case law, whether we want to or not.
Yes, definitely. I mean, especially the courts as the Court of Justice, which deals with these questions that you can say constitutional questions in the sense that it is interpreting a text, because lawyers start from text, but text that is very vague. Yeah. But the court, when it gets the question or a dispute, the court has to solve it. So the court has to get into that text and think about, well, what is it? What does it mean? Why do we have it there? Dig a little bit, and we do that into past and see why we do it. If you can, very often you can't. Then you have to think about why do you have it. But if you, for example, in my view, really read Article 2, you cannot say that a certain politics could fit into it. So my idea when I said that this was the idea of society that the member states had in mind when they created the European Union was the idea that, you know, they did have that shared notion. It is vague, but they had some basic shared notion of what they want. They want a society in which individuals are important, in which individuals have certain choices that the state or public power cannot just mess as they want, but has to be controlled, no? And that there must be someone who controls it as well, this public power, so that then you necessarily come then to the courts, you know? And somehow this rough picture is there. Now, how exactly you turn it into institutions and procedures may differ very much from state to state and on the European Union level. However, the basic idea, in my view, is shared. And in my view, it is very difficult not to recognize a model of liberal democracy in there. We need to have a concept of human dignity. If a society doesn't have a concept of human dignity, then that society cannot be part of the European Union, or it can, but then European Union has to change. Then there is a mismatch, and obviously current European Union wouldn't be able to function, being so much connected and having so much regulatory powers, because we decide so many issues on the European Union level, and on the other hand depend on member states for this to be implemented, applied. It wouldn't function simply if there is no certain basic level of understanding what is good society in that sense.
One critical question though is sort of who should be defending the baseline rights? Do you recognize this danger of sort of over judicializing the values debates, and how do we avoid that risk?
Yes, I mean, obviously I was trying to be cautious in my opinion and try to say this, that in a way Article 2, if used, is to be used only in exceptional circumstances. Otherwise you don't have to go there, because otherwise you have to leave the room for maybe different viewpoints, which at certain point might settle somewhere. And this settling might go, and should probably go in many aspects, through society, or should go through the conversation between courts. If you're at the constitutional level, what we can control as courts is just this, red lines. And red lines are something that are so clear to see. My usual example now is the country decides we are not having these elections nor any others, we stay in power, no? This is obviously contrary to Article 2. So this is what I have in mind. What is problematic, of course, is how to define where are these red lines. When are you over these red lines and courts can really react, and when you are not. And this is going to be something to be resolved for the future, if the court accepts at all that Article 2 is usable by the court.
Wonderful. Tamara Ćapeta, Ana Bobić, thank you so much for talking to us.
Thank you, Mark.